Evaluate the view that the US President has too much power within the US Constitution. When the Founding Fathers negotiated a constitution in 1787, there was a deliberate tension set between the desire to have both an accountable government with also the desire to have an efficient government. And this was born out of the fact that they had fought a war of independence against a tyrannical British king and yet faced enemies on all sides. Over the last 225 years, this tension has remained, and nowhere more so in the balance between an accountable president and a president who was able to fulfil his duties under Article 2 of the Constitution. Any Google search linking the President and the Constitution will recognise that almost from its inception, presidents have either sought to limit themselves to the restrictions set in Article 2, and those presidents like Lincoln, FDR, Reagan and Bush, who have arguably interpreted the role of president in a much more expansive way, in line with the view alluded to in the question that they have too much power beyond that which the Constitution permits. This answer will consider the role of the President in both domestic and foreign policy, his relationship with the Congress, the circumstances post 9/11, the veto power, the 22nd Amendment, treaty making, the unitary executive authority, and the reinterpretation of signing statements. Those who concede that the President has become more powerful than the Constitution delineated, such as Morton Goodson, argue that the Constitution itself was deliberately left ambiguous, in part to allow for changing circumstances. The reality of nuclear weapons and a complex capitalist economy compared to the cannons and 718 soldiers that Washington had at its disposal in 1789, and the largely rural slave-based economy of the period, has determined that presidents would be inclined and indeed encouraged to enlarge their office. In other words, the president has become powerful, but not too powerful, and his powers have simply mirrored the need to operate as a world superpower. Arthur Schlesinger, who was both an historian and member of the Kennedy White House, was keen to argue that the words recommend measures, as stated in Article 2, Section 3, were elastic enough to justify the presidency expanding to meet crises such as the Depression, World War II, civil rights, and Great Society issues in the 20th century. In this sense, Schlesinger saw a strong president, even an imperial president, for he coined the term itself, as consistent with the role set out in the Constitution. In addition, for a president with broad interpretation of their powers, implied in the constitutional provision for the President to recommend measures, Article 2, Section 3. This recommendation, especially in foreign policy and in time of crises, has come to resemble more of a directive or order due to the fact that, say, in a terrorist situation, there is not the time for the Congress to deliberate when the President can make a quick response. The President has also added a mandate theory from the Constitution, which implies that even with the oddity of the Electoral College, that he remains the only directly elected national public official, and therefore his powers are embedded in Article 2, Section 1. The purists, such as Judge Andrew Napolitano, counter that the Constitution was never designed to allow for such aggrandizement of power, and that his powers were only those directly stated in Article 2. As a Fox News legal correspondent, he has been regularly critical of the growth of what he calls executive power. However, he comes from the libertarian perspective that broadly is sceptical of the whole federal system and embraces states and individual rights. In discussion with Charles Penna, Napolitano made the point that the area where the President had exercised power beyond the Constitution was in foreign policy. Penna saw the Constitution as giving the President limited power to respond, but only where the US national security interests were under threat, but that modern presidents, including Bush and now Obama, have greatly expanded this power. The War Powers Act, passed by the Congress in 1973, ostensibly to rein in Richard Nixon and his unconstitutional bombing of Cambodia, has actually made it easier for the President to act more freely militarily. It is described as toy handcuffs on the hands of the President. Pena does not entirely blame the President, but rather argues that the President has limited powers within the Constitution, but that the Congress has abdicated their duties to hold him to account and allowed presidents too much power. Their perspective can be summed up as one which partly accepts the assertion in the question, but lays the blame at a spineless Congress who fears accusations of a lack of patriotism if they seek to curtail presidents' foreign adventures. It is politics that effectively undermines the balance of the Constitution and tips it towards a strong president. Another factor in the emergence of the imperial presidency has been the attitude of the American people. They are somewhat schizophrenic about presidential power. They've expected presidents to find cures for economic problems, like FDR in the 1930s, and Bush and Obama following the banking crises since 2008. However, they are also quick to pass judgment on the president in the polls, as they did, for instance, in the 2010 midterms to Obama. And arguably, the constitutional requirement of re-election in Article 2 still works fairly effectively, given the one-term nature of, say, the recent Carter and Bush senior presidencies. A counter to the view of the President having too much power in the Constitution lies also the significant restraints put upon the President by the 22nd Amendment. The lame duck nature of the presidency counters the assertion in the question and comes close to creating what Gerald Ford called the imperiled presidency. Linked to this is the view that the presidents such as Reagan have attempted to bypass the Constitution in what was called Iran-gate, and the illegal funding of the Contras in Nicaragua and a covert foreign policy towards Iran in the 1980s, suggests that the limits placed upon a president are still significant. And the fact that the Congress ultimately has been able to curb this type of unconstitutional behaviour suggests that the question's assertion is misplaced. This could also be seen in the fact that although unsuccessful, Bill Clinton was impeached in the 1990s. In recent years, the currency of this question has become more pertinent, with concerns being voiced about the so-called unitary executive, the use of the veto, the bypassing of treaties via executive agreements, and the role of signing statements. For commentators such as Robert Turner from Virginia Law School, this is not a bending of the Constitution, but the President fulfilling his constitutional duties to, quote, faithfully execute the laws, unquote, and the curtailing of civil liberties, suspension of habeas corpus, secret wiretapping, and intrusion into emails and what library books people are borrowing is fundamentally constitutional, since the measures sought in the Patriot Act were fully endorsed by the Congress and subject to the necessary congressional oversight. The view is challenged by Eric Posner from the University of Chicago, who argues that the courts have been too slow and Congress too divided to challenge presidential power. In essence, the checks that are supposed to be provided by these branches is inadequate, and Posner would arguably say that the President is only getting away with what he can get away with constitutionally, and that the other branches are too weak within the Constitution. This contrasts with earlier periods when the Supreme Court, for instance in 1952, ruled that Truman's power as Commander-in-Chief did not extend or permit him to take over US steel mills during the Korean War. The defeat of the Comprehensive Test Ban Treaty in the 1990s by the Senate tends to run in contrast to the view that the President has too much power. Some critics, like Larry Sabato, have felt that the Constitution did not give the President the role of chief legislator, which he has effectively claimed and grabbed, and therefore assumed a position beyond that given him constitutionally. However, this is hardly too much power, since even though, say, Obama dominates the legislative agenda, he had to fight hard for the healthcare bill and recently for a budget deal to prevent the shutdown of federal government. Compared to, say, a UK PM, he is a weak legislator. The key factor here is less constitutional and more political. If a president like FDR enjoys party control over Congress, he can hope to push a legislative agenda. If, like, say, Clinton or Reagan, he is facing a split Congress, he is only what Neustadt called power to persuade, a very necessary restriction and a limit to his power within the Constitution. The Constitution, after all, did not conceive of party politics, and in that sense, the power struggles that involve presidents and Congress operate outside the Constitution, and therefore this question is not placed properly. The view that the Supreme Court has failed to exercise control over power-hungry presidents is not justified. Probably more than Congress, they've stepped in to limit presidential ambition. For instance, in Hamdan v. Rumsfeld, they ruled the holding of terror suspects in Guantanamo Bay without due process was unconstitutional. And in Clinton versus City of New York, they took away this power as unconstitutional, the power being that of line item veto. In this respect, the claim of presidents being too powerful within the Constitution is not valid. Yet the concerns over an imperial presidency remain. The term unitary executive authority came to the fore when Supreme Court nominee and now Justice Sam Alito argued that in some respects the President was above the law. This is linked to signing statements, the time of which has been seen since President Reagan started them and was taken to new heights by Bush and even Obama. At the time of signing a law, which is usually seen as a celebratory event with special pens and photo opportunity for those involved in the legislation, presidents have taken the opportunity to effectively decide which parts of the law they wish to apply and how they wish to spend the funds relevant to the law. Charlie Savage has pointed out how over 1,000 laws that Bush signed were actually challenged by him in such signing statements. This included such things as the torture ban and those that provided affirmative action. Savage also argues that this is an attempt by the President to gain more power than provided in the Constitution, and one to date that the courts and Congress have failed to challenge. Again, like some child in a sweet shop, the President will take unless and until the other branches exercise restraint. The war-making power is also seen as an area where the President has claimed excessive power beyond his constitutional rights. Only 5 times since 1789 has the Congress declared war, and yet force has been used by US presidents more than 160 times. Critics like Nelson Polsby pointed out that again this shows less about the President's late claim of unconstitutional power and the Congress giving the President a blank cheque or freedom to run foreign policy. The Gulf of Tonkin resolution is oft quoted as such a blank cheque, and although the War Power Act and the Case Act of the 1970s sought and seek to restrain presidents post-Vietnam, the examples of Kosovo, Afghanistan and now Libya indicate a dominance of the President in this area because the Congress is unwilling or politically afraid to fulfil its constitutional obligations. Related to this is a concern over the treaty-making power of the President. Given that Versailles was not ratified and the Comprehensive Test Ban Treaty in 1992 was rejected by the Senate, it is hardly surprising that presidents who regard their foreign policy role as central should attempt to wriggle free from their constitutional obligations. The use of executive agreements, for instance, as a bypass of the treaty ratification process, provides ammunition for those who view the precedent as subverting the Constitution and certainly exercising powers beyond it. A final area is the question whether the use of the veto and its regular and pocket form give the President too much power. However, this still remains part of the original fabric of the original Constitution and a necessary counter-majoritarian weapon. However, David Nair from Columbus University argued in the 1990s with the Clinton presidency that the use of the veto by modern presidents does amount to exercising power beyond the meaning of the Constitution. He said that it amounted to blackmail, and given the 2/3 override rule, it is usually a successful form of blackmail. It also effectively hands a form of legislative power to the executive branch in contravention to the aims of the framers, who saw the Congress as the proper place to produce legislation. The veto, therefore, as interpreted from FDR onwards, has granted the President powers beyond those intended by the Constitution. And finally, in conclusion, it can be argued that the power grab of modern presidents is hardly surprising, and partly due to the failure of Congress to stand up to presidents. It can also be seen as part of an historical trend towards allowing more power in the executive, because it is, after all, more flexible in dealing with the kinds of military, diplomatic and economic crises that, say, 535 legislators, and more democratic although more democratic, are slower and certainly more proactive than the Supreme Court. It is ironic that of all the presidents who contributed most to the expansion of the role of the president, and arguably taken his powers beyond those of the Constitution, are those that tend to be admired most in the United States: Lincoln, FDR, Theodore Roosevelt and Reagan.